Good morning and welcome to Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you everybody for being here. I can already see we have a bunch of people in the chat and a bunch of people watching. Hello to Black Witter and Shy Gal and Alicia K. Mayo and P. Lola's mom, a bunch of people who I know also left us messages. I was talking with Kaylin. We were going over everything that we're going to talk about on the show today, and it's a lot of really fun stuff, and we've got some interesting content to share with you, and also, you know, the questions are incredible, and then I've got some juicy stories that I will share with you, so buckle up. For those of you, we know that on these Sundays we get a lot of new people watching. My name is Joshua Ritter. I am a former LA County prosecutor for a decade, and now I am a criminal defense attorney in Los Angeles, and we have made it our mission here on this channel to try to present to you as best we can both sides of the courtroom. So we're going to go through a bunch of voice messages that you guys left. We put out the call again. You guys did not disappoint. Some really interesting thoughts, and again, it never ceases to amaze me how much of these questions are something I never would have thought to talk about, but they bring back old cases and new cases that we're talking about, thinking about them in an interesting and new way. So I appreciate you all. Thank you so much for leaving all of those messages. And stay to the end. We've got some announcements about what's coming on this week, some guests that we have that I think you guys will be excited about. Oh yeah, and some other fun stuff. It's going to be good. We're going to have a really fun morning. All right, let's jump into it. And let the messages begin. And hopefully, I'm praying and this is what'll help. Go ahead and hit the like button. Go ahead and subscribe if you haven't already. And I think that somehow that will get the good mojo going so that we don't have any technical difficulties, because I have to run a lot of this. If it's all in Kaylin's hands, we're fine. If it's me trying to run some things, we're going to have some trouble. P. Lola's mom says, Sunday Fun Day, cash train, love this community. Thank you so much. All right, let's get going on this. How do I do this? Please tell me, Kaylin, you're going to have to tell me if you hear these things, okay? Here we go. Question number 1. Nope. Okay. Already.
Hi, Josh. This is Cynthia Bauman.
Uh-oh. Now you can't hear it? What is going on? What did I do wrong, Kaylin? Okay.
Or forensic professionals or even witnesses sort of to the wolves and potentially wrecking their guilty about throwing files. Hi, Josh. This is Cynthia Bauman, and I'm calling because I watch a lot of trials, and I was wondering if defense attorneys ever feel guilty, or, you know, when you're the defense attorney, do you ever feel guilty about throwing law enforcement or forensic professionals or even witnesses sort of to the wolves and potentially wrecking their career in pursuit of getting a client off? Thanks. Bye.
Sorry about that, guys. I hope you heard Cynthia's message. It was a really good question. It's still early. Sorry, I'm still a little groggy. We're shaking off the cobwebs. I'll get this all figured out. But she asked, do you ever feel guilty throwing law enforcement to the wolves and the fact that it could affect people's careers? And that's a great question. And I think this comes down to kind of the fundamental question of what is a defense attorney's job? And, you know, I think most defense attorneys would give you the answer of, my job is to zealously defend my client. Listen, you have people who have hired you. They are looking at a life-changing event to take place in their life. And a lot of it is in your hands. they could go to prison for the rest of their lives. And so your job, and it's not just to say your job, it's also to say that your constitutional duty, your duty, what you've sworn and taken an oath to uphold the Constitution, and the require holding a bar card, are that you, at all cost, except for violating ethics and the law, are supposed to defend your client. Now, obviously, you can make strategic choices. But sometimes, a lot of times, that means attacking law enforcement. Have I ever had to cross-examine police officers? Absolutely. I feel that you can do that in a way that's respectful, and at the same time go after them if they've made mistakes, or if they've been very short-sighted or myopic in the way that they've investigated the case. Absolutely. It's all fair game, right? And I think there's a way to do that respectfully. Is there a way to do that that also crosses the line where you are calling into question this person that may affect the rest of their career? I think that's good, a good thing to ask too, and a good question to consider as well. I have never done that, what I feel is close to that. I had one case where I felt that the investigating officer was so misplaced and so misguided in his pursuit of my client that I felt if he's that dead set on doing what he's doing and going after my client, then I can be dead set in going after him. Now, I didn't ruin this man's career, but I do know that the way that we cross-examined him and the way that that trial ended up, I heard from coworkers of his that said that he got reassigned and that things were that he did not get fired, but I don't blame that on me. I blame that on the way that he did his job. I know I'm kind of rambling on here, but I guess what I'm saying is that I'm never the type who's going to play dirty, but you can see how if you've got a client there who's like, you've got my life in their hands, you're going to want to do everything that you possibly can. Where defense attorneys start to cross the line, and I think that some of them do, is when I think they start to play dirty, and it goes beyond zealously defending your client, and it steps into the territory of just lighting a match to everything that gets in their path. I don't know if that answers your question, Cynthia. It's a great question. It's probably a question I'm going to be thinking about much later beyond this show, but I love that question. Thank you so much. All right, let's move on. Let me see if I'm doing this right again. I hope that I am. Tell me if you can hear this.
Hi, Josh. This is Donna from South Carolina. Just curious. I was watching. I came in late. I'm lurking now, and I'm watching the replay. But the woman who asked the question about the that you were talking about the and all that, and I'm just kind of curious. I tried to see if I could Google it on California cases, because I know that's where you were. And when you mentioned that the train wreck was in 2005, I kind of looked, and there were a bunch of cases about murders and mass murders and spree killers and all of that. And it didn't, nothing came up that had anything about a severed head. So I'm just kind of curious if there's a case name that, you could give us, so you kind of, check out that case, because it sounds fascinating. And I realize this is going to be something that you're not going to catch for a couple weeks, because you just finished it for this week. So, but anyway, that's my question. Thanks for everything you do. I really appreciate it, and I'm sure everybody else does. Thank you.
Okay, Donna from South Carolina. Great question. And it cut off a little bit. The file got corrupted somehow in her question, but she's asking about a case that we had talked about a little while ago. It was one of the first cases that I ever worked on as a law clerk in the major crimes division. And somebody had asked the question, have you ever seen pictures that are just so disturbing to you? And I started to talk about this case, and I gave some vague details about it, but I didn't go into all of it. So I will story time, and I'm going to tell you guys this entire story. This is probably actually something that I should save for a members only live, but because you guys have asked about it, I feel like you want to hear the story. But I will tell you this, it is graphic, and it's not It's graphic in a gross murder type of way. Probably stuff that you guys have already heard, things that you've heard before or can imagine. But I just want to give you that heads up that I'm not gonna get too gross about it, but I'll tell the actual details of what took place. And it's funny. The guy who prosecuted this is a good friend of mine. His name is Rick Ocampo, and he's now a judge. We're actually going to talk about him a little bit later. But at the time, he was there he is. He was a prosecutor in the major crimes unit, and he had this case. And it's funny, when I got this question, I called him up yesterday to just kind of make sure I had the details right. And I said to him, Rick, do you remember that case back when I was a law clerk? And it was about a guy who committed a residential burglary. And he goes, Keven Graff. First thing that came out of his mouth. He knew immediately what I was talking about, because the facts and details of this case are something that you're never going to forget. So Keven Graff was a gentleman, I believe he had a military background, but was going through about one of the most severe mental crises that you can imagine. His mental health had deteriorated to the point that he was really untethered from reality. This is in June of 2004. He breaks into a random person's home. Nothing against this person, had not been stalking this person, had no knowledge of who this person was. And the man whose home he broke into was a man by the name of Robert Lees, Lees, who was a Hollywood producer and writer from back in the Abbott and Costello days. He was 91 years old at the time. Breaks into this man's home, kills him in about one of the most brutal ways that you can imagine. I'm talking about cutting him open. I'm talking about organs being removed. The way that it was described by Rick was that his body was eviscerated. So you can imagine what that means. But what he also did was decapitate Mr. Lees. And I was unclear if he waited until the evening or until the next day. But at some point, he hops the fence between Mr. Lee's home and the neighbor's home. And he brings along with him Mr. Lee's head. And this is the graphic part. So plug your ears if you, it was all graphic, but this is the really graphic part. Plug your ears if this is the kind of stuff you can't stand. The way that he carried his head was that he took a belt and he looped it through the open neck hole of the head and out of his mouth to fashion a handle so that he could carry his head from the first location to the next location. And once he got to that person's home, he was now in the home of a gentleman who's 69 years old named Morley Engelson. Morley was just a retired gentleman. I think he was involved in kind of the banking industry or something like that. Again, somebody that this man, Keven Graff, had no connection to whatsoever. And Morley is on the phone with Southwest Airlines at the time that he breaks in, and he's attacked by, I believe, a fire poker by Graff, and Graff bludgeons him to death as he's on the phone with the Southwest ticket attendant. And the ticket agent calls 911 because she hears the attack. That's how police knew to come out, because otherwise, no one was noticing these murders. When police arrive, they find that Mr. Engelson has tragically also been savagely killed. His body also described as eviscerated. And the part that stood out in my brain and has been forever scarred into my brain is the photograph of Mr. Lee's head placed perfectly in the center of a brand new and perfectly made bed. And that was Mr. Engelson's bed. And that's where he laid his head, and where police found it and where they photographed it. About one of the most brutal cases if you're ever going to hear about. You can find news about it. It didn't get all this coverage. It didn't have a bunch of documentaries made about it. There's no podcasts about it that I know of. Just an incredibly horrible, brutal murder that is unfortunately the type of things that happen in large metropolitan areas that just sometimes go unnoticed. And The way this all resolved is that the DA's office was going to pursue the death penalty against this, but he ended up taking a plea of life without parole. So I don't know where he's at now, Mr. Graff, but he has been sentenced to life without parole. So that was the case that Donna was asking about. I love that we jumped into something that graphic so early on in all of this, but just to show you how much fun we're going to have today. But that is the case that I had referenced when somebody was asking me, do you ever see graphic photos? That's something that still can't get that image out of my head. But yeah, that's the kind of stuff that you will deal with in a prosecutor's office. And you know, imagine being the investigating officers, right? You're just called out. Think about this. They get a 911 call, and it's the ticket agent, and they say somebody's screaming on the phone. So they send out a couple of patrol units, right? They don't know what they're walking into. They don't know if it's a domestic violence situation. They don't know if it's a guy had a heart attack. They don't know what in the world is going on that they're walking into. They're probably going in there, arms, their guns drawn, expecting perhaps trouble, and they walk in on one of the bloodiest and most horrific scenes that you can imagine. And then I imagine initially they don't know who the head belongs to, right? There's an unidentified victim's head in the bedroom on the bed. And it wasn't until later, I think, actually, that Mr. Lee's wife comes home and discovers his decapitated body in the home. So there's a little nightmare fuel for you early on a Sunday morning, right? All right, let's move on now back to our other calls. But thank you again for that question, Cindy or Donna, pardon me. All right, let's move on. Did we have questions on that, by the way? If we've got questions, Caitlin, I'll take them. But could you have tried that case using an insanity defense? I think that's what was going to happen. I think that there was no way that would have gone. He demonstrated some real mental health issues, and I think that's why it pled. I think otherwise they would have just taken that to trial. But I think that they knew, the prosecutor's office, knew that was probably going to be the defense, that they likely would have had a good shot at that. The defense knew that he was likely going to get the death penalty if he was found guilty. So that's why you arrived at an LWOP plea. But wow, heck of a case. You can look it up. Keven. Oh, it's spelled Keven, spelled weird. Keven, Graff, Graff, if you guys want to look it up. How long did it take to catch him? Because I guess he had already left by then. Yeah, he was gone. Somebody with that severe mental health is just going to show up on police radar if they're looking for someone, but he was not at the scene when police arrived. Great question, Marta. All right, let's move on to our next question here.
Hi, Josh. This is Maureen. I have a comment about a question you were asked in this morning's Sunday Fun Day. You had a question about expert witnesses and whether they lie. And I just wanted to recount a story. I was on staff at Stanford in the Department of Anesthesiology, and I happened to get to know Dr. Stephen Schaefer, an anesthesiologist there, who was the expert witness against Dr. Conrad Murray in the trial for killing, basically, Michael Jackson. And he told me that he did that for no fee at all. And the reason he did was because he was outraged by the out-of-hospital use of propofol and this absolutely unnecessary death. So I just wanted to tell you that, and I was wondering if you ever happen upon experts who are willing to testify for no fee at all. I imagine it doesn't happen very often. Thanks, Josh. I love your shows. I have a zillion questions, so will undoubtedly be hearing from me in the future. But keep up the wonderful work. Bye-bye.
Thank you so much, Maureen, and I hope we do hear from you in the future, because those are some really, really excellent questions. So Maureen brings up the case of Conrad Murray. This was another case that was tried while I was in the DA's office in the major crimes unit, right towards the tail end before I got hired as a DA myself. He was the doctor who was treating Michael Jackson. He was charged with manslaughter for basically overdosing him on propofol, which is a heavy duty anesthetic. I don't know what you want to call it, drug, narcotic used for basically, rendering people unconscious. And Michael Jackson had been using it to treat insomnia. And this doctor had been the one prescribing it and administering it to him. This is not pill form. This is something that has to be injected through a drip. And, just an awful case. And it was prosecuted by a very still good friend and mentor of mine named David Walgren, phenomenal prosecutor. He's now a judge as well. All these guys become judges. If they don't become judges, they go on YouTube. That's just kind of the career paths that everybody takes from the DA's office. And yes, Dr. Stephen Schaefer, who was a leading expert in anesthetic propofol, took the stand and testified about just how bad this was, because the defense's theory was, listen, this stuff is strong stuff, but under a doctor's care, it can be administered. It can be used to treat things like what Michael Jackson was dealing with. Michael Jackson was asking for it in the sense that he was saying, give me that. I need it for sleep. I'm in pain. All of these types of things. They were trying to kind of paint Dr. Murray as almost as a mercy physician, and Stephen Schaefer was a phenomenal expert and probably the key witness for the prosecution in saying, absolutely no dice. This is such dangerous stuff. You were basically playing Russian roulette with this man's life. And he was convicted, and he only got 4 years. And he only served 2 of that. So he's been out for some time. I mean, this happened back in the around 2010 or something like that, 2009 maybe. And so he's been out for a long time. And I tried to look up what he's up to, and there have been a few stories here and there about him maybe kind of trying to practice medicine or something like that. But Dave Walgren did a fantastic job with that. But Stephen Schaefer testified, and he testified for no fee. And the question that Maureen asks is, one, do you ever experience experts testifying for no fee? On the prosecution side of things, many of their experts are not testifying for a fee because they are government employees. So your medical examiner, for example, that's just their job. They work for the coroner's department. They perform autopsies. And when subpoenaed to testify, they go testify. They don't get an extra fee for that. Your gang experts, your crime scene investigators, all these people are on the payroll. So there's no real fee. Every once in a while, you will have to get someone to testify as an expert. As a prosecutor, sometimes though, you can convince these people. You can also just, if they've somehow made themselves a part of the case. In other words, had Dr. Schaefer somehow treated Michael Jackson, they would have just subpoenaed him and he wouldn't have had a choice. But if you got somebody who's just an expert in their field and you want them to testify, many times there might be a fee involved, but it was rare for me to ever experience it. I never in my career actually hired an expert. I know that maybe in a handful of cases, and I don't need to use all my fingers, there might have been instances where the prosecutor paid somebody out of pocket. The defense, however, is nearly paying everyone because they're going out and hiring people who have nothing to do with the case. It's not part of their job, and they're being asked to render an opinion, and they need to be paid for that. This is what they do for a living for the most part. They might be academics and they might treat patients themselves, but for the most part, a large part of their income is coming from testifying as experts. Crazy Mom RN says, he was stripped of his medical license, though. Yes, Murray was. I was under the impression if a felony, you cannot practice. Yeah, he was stripped of his licenses wherever he had a license to practice. So what was I saying? Oh, so yes, the defense is going to hire people. They need to. I mean, it's just a function of the way this works. There's not going to be a person available. If the defense doesn't want to use the prosecution's experts, that is, they're going to use the prosecution's medical examiner, right? They're the one that performed the autopsy. They just cross-examine that person. They may even recall that person as their own witness if they want to get into something else. Same thing with the drug experts or chemists or all these other kind of scientific experts. But if you want to call in someone to talk about eyewitness identification or something, you're going to need to hire that person. You want to call in a dog bite expert, you're likely going to need to pay that person. But sometimes these people want to get involved and they benevolently offer their services for free, and defense attorneys will absolutely take advantage of all of that. Now, her first question was, do expert witnesses ever lie? And I really love that question. And here's how I'm going to answer it. Yes. So, my Cologne did it. Smurf Anna, love the name, says, so the fact that the ARCA experts talking about in the Karen Reed trial were originally third party is highly unusual, very unusual. And that's why the defense highlighted that so much. You remember Alan Jackson's opening salvo of questions to the ARCA expert was, you never met me. You never talked to me. You never talked to her. You never talked to Liza Little. You never talked to David Unetti. You never talked to my client. You don't know, we never paid you. That was a big deal for the defense to be able to do something like that. Yes, that was a gift that landed in their lap, that there happened to be an expert that was hired by somebody else who was willing to testify. And by the way, their opinion was favorable to the defense. So great question. But the question here that Maureen asks is, do they ever lie? I don't think you're going to find a expert who will, quote unquote, lie. In other words, will they perjure themselves on the stand? That, I think, is incredibly rare. Dr. Smith, what color is the sky? The sky is green. You're never going to tell somebody who's just going to flat out lie to the jury. Because they have to make a career of this. They have their reputations. They want to be honest brokers as well. And they realize that they're not going to get much business if they're known to be absolute liars and are found to have perjured themselves. And by the way, perjury is a crime. Okay. But always bear this in mind. Experts are dealing in the world of opinion, okay? They are rarely being asked questions that are black and white, that do have a truth and falseness to them. They're being asked their opinion on something. So, doctor, given XYZ, what is your opinion? Well, now, opinion can be far more gray area, right? Opinions can differ from people to people. As long as you can support your opinion can be fairly wild. And will experts give opinions favorable to those paying them? Absolutely. I think to say otherwise is just completely ignorant and not true. They are paid. Listen, you are a defense type of expert. You get paid to give opinions that are favorable to the defense. If you are not, then you are not getting phone calls. One of the en vogue type of experts that we used to get a lot when I was a prosecutor was eyewitness identification experts. And there was about a handful of them. And they got called in nearly every case where that became an issue. Now, listen, they would, of course, arrive at the opinion. I never saw a case where they felt that the circumstances were ripe for a good eyewitness identification. So every single case that they had, they could find some evidence in there to render their opinion that the ID identification in this case could not be trusted. Now, do you want to call that lying, or do you want to just call that somebody taking full advantage of what the word opinion means? That's what I'll say about that. And that's why I'm incredibly skeptical when cases come down to a battle of the experts, because you can find an expert for nearly both sides of almost every issue you ever want to think of. And that works for the prosecution as well. The prosecution's experts are going to be law enforcement people, and they're likely going to have opinions that are favorable to the prosecution. So just because you have opposing experts, to me, doesn't necessarily mean all that much. And just because you have an expert saying something doesn't mean, I certainly would not render an entire opinion based upon an expert's opinion. An entire verdict, I should say, based upon an expert's opinion. Joy W says, experts are brought in to explain difficult or highly technical topics for the jury. Correct. Yes, they are. They're brought in to explain these highly technical, scientific, not easy to understand things, and then likely render an opinion on that. Okay, based upon your evaluation of this case, based upon the police reports, based upon this and that, do you have an opinion as to whether or not this accident was caused by a car injury? These injuries are from a dog bite. This person was able to eyewitness identify that other person. Whatever that opinion is, yes, I do have an opinion. And what is that opinion? My opinion is that there's no way. My opinion is that there's that it's absolutely true. Whatever it is. So you're right, Joy W. They're supposed to educate, but then they're kind of not worth their salt if they're not rendering some sort of an opinion. Great question, guys. Great questions. Thank you so much, Maureen. Appreciate it. All right, let's get moving on to our next one here.
Oh, Joshua. This is Alicia K. Mayo from Tennessee. Hello to the Crew family. I'm stunned. I'm sorry. Pardon my stammering. It's Monday, March 3rd. I just saw a post on X. Can you, one, explain what subsex is and what in the name of dirt and worms is Casey Anthony doing on there? Can you explain that? Oh, I'm in my feels. Happy Sunday, y'all. Bye.
Oh, Alicia, you bring so much joy to my heart. Thank you for that question. This is something a lot of people have been asking about, is Casey Anthony making her return, trying to rebrand herself, and making her, there she is. There was her, how many years ago are we talking about now? Can somebody look that up really quick? We're talking about decades ago. On trial for killing her daughter, Kaylee. It was one of those cases that was just, captured the entire attention of the country. A lot of people had incredibly strong feelings about this. I think most people leaned in favor of the idea that she was responsible for her beautiful daughter's death. I got to tell you guys, it is incredibly difficult for me looking at pictures like this. I think you all know I have 3 beautiful little girls who are all under the age of 5. And the idea that that anyone would hurt them on purpose floors me. And I would probably, move space and time to make sure that nothing harmed them. So these types of cases really hit me in the gut. July 5th, 2011 was the verdict. So yeah, wow. We're going on what? 16 years now. That's incredible. Anyhow, 16 years later, Casey Anthony has decided she's going to try to rebrand herself, and she puts this video that we're going to show you. I think she released it on TikTok, but it got released on X and Instagram and everywhere else. So take a look at this, guys.
We're sweat to death. Okay. Today is Saturday, March 1st, 2025. This is my first of probably many recordings on a series that I'm starting. I am a legal advocate. I am a researcher. I've been in the legal field since 2011. And in this capacity, I feel that it's necessary, if I'm going to continue to operate appropriately as a legal advocate, that I start to advocate for myself and also advocate for my daughter. For those of you who don't know, my name is Casey Anthony. My daughter is Kaylee Anthony. My parents are George and Cindy Anthony. This is not about them. This is not in response to anything that they have said or done. That's not to say that I'm not going to respond at some point to some of the things that they have said and done. The whole point of this is for me to begin to reintroduce myself. I'm doing this both personally for me, but in a professional capacity. Moving forward, the majority of what you will see will be me speaking in a professional capacity. My goal is to continue to help give a voice to people, to give people tools and resources that they can utilize so they actually know where they can turn to. So with that, please join me on Substack. If you have questions, I will set up an email address where we can correspond directly. Up until this point, that has never happened. And it's only going to be on a limited basis regarding legal issues, legal matters. One of the main reasons that I'm doing this, there are people close to me who have been targeted and attacked recently. There are also people close to me who have had some recent things occur. And when necessary, people needed to step up, myself included. So as a proponent for the LGBTQ community, for our legal community, women's rights, I feel that it's important that I use this platform that was thrust upon me and now look at as a blessing as opposed to the curse that it has been since 2008. With that, these aren't going to be perfect. They're not going to be edited. Most of the time, they're not going to be short. But I am proverbially standing in the light, embracing this piece, still going to keep my privacy intact. So you will get very comfortable with my car, and I will explain in great detail why it's so important for people to protect their privacy.
No, go ahead. Let's go ahead and finish it. We're almost done.
It's not just important to public figures, it's even more important to private individuals. And with the current climate in our country especially, it's that much more important, which is why I am utilizing the Substack platform. Yes, I am advertising this and publishing this on TikTok, possibly also through other meta platforms, but my intention is to separate from that and showcase even more why Substack is such an important resource for people to utilize moving forward. Anyway, I appreciate your time, and we'll see how this goes.
Wow. I love Future's comments. My eyes rolled back so far. I'm looking at the wall behind me. Yeah, my eyes muscles, eye rolling muscles are actually making noises. They're rolling so hard. So listen, a lot of people have been reacting to this. Obviously, we all find it disgusting, distasteful, socially deaf, pathetic, sad, whatever you want to call it. I think no one wants to be hearing from this person. No one cares about her rebranding. No one cares about her legal advocacy, whatever the hell that is. I think it was repugnant to hear her talk about doing this on behalf of her daughter, at being a voice for her. We're all sickened. Okay. I get it. But it raises a couple of interesting points, and I don't even know where I fall on this. But there is this disconnect, right, between what happens in court and what happens in the real world. And that disconnect is called the burden of proof. What happens in court has to be proven beyond a reasonable doubt. And that's super, super important. But that doesn't mean that we all are bound by that. We can sit and watch and hear the evidence and have some incredibly strong feelings about how cases have turned out. And there have been a lot of cases that people are not happy with and disagree with the verdict. This being one of them, OJ being another one. We could probably sit here and list quite a few of them. And it presents this interesting question because we, as a society, say, listen, we're going to put somebody on trial and we're going to stand by that verdict, right? And if somebody is acquitted, well, then they're acquitted. And according to the law, they get back everything. They get back their freedom. They get back they don't have a conviction as a felon. They don't suffer all of those consequences of being a felon. They don't, their life is supposed to be returned to what it was. And we do that because sometimes the police get it wrong, and sometimes prosecutors get it wrong, and sometimes innocent people are brought up on charges. And when they are vindicated and they are acquitted, we all as a society sit back and applaud that and hope they move on to a very fruitful and successful future, prosperous future. But what do you do about the cases where the law does what it's going to do and the criminal justice system does what it's going to do, but we all feel very differently from that? Does that mean that people should be able to move on? Should Casey Anthony, an acquitted person, be able to move on and have a life and rebrand herself? Or is she ever for forever to carry around this brand of being the person that we all believe her to be? I don't know if there's a really simple answer to that. I think that we all as a society can say, yes, we're not putting you in prison. We're not locking you up. We're not going to treat you of all the dire consequences of having been a convicted felon. But we don't have to like it. We don't have to embrace you. We don't have to act like what you did didn't happen. Same thing happened with OJ. If you remember, that's a great question, Pamela, and I'm going to get to it in a second. But you remember with OJ, there was some documentaries that have come out recently about him, and some of the most fascinating parts of the documentary to me are what happened after the acquittal and how he tried to like have this life again. He just expected everyone to go back to normal. And he wanted to go back to his golf club and hang out with his buddies and be a celebrity again and have people, the restaurants open up doors for him and people buy him drinks. And he thought, in his deluded mind, thought life would just go back to normal. And it never did. And society had turned on him and he couldn't find work. And he went into all sorts of weird rebrandings, and at one point he tried to become a rapper. At another point he tried to have some sort of reality prank show. It was sad and miserable, and that's because there's a difference between what happens in the courtroom and what happens outside of it. And I as much as I agree that somebody who's been acquitted should enjoy all of the legal benefits of that, that doesn't mean necessarily that culturally we are as forgiving. Pamela H says, Casey Anthony sounds like she's impersonating a lawyer. I hope she gives out legal advice. She can't get in trouble for that. Can't she get in trouble for that? I don't know what even she's talking about. A legal advocate. That makes no sense to me. And I absolutely am fascinated and, pity the people who would actually go to her for any sort of legal advocacy. I think this is just desperate. I think it's a sad person who has never been able to move on from what they did, never can find a place for acceptance. And now she's trying this weird rebranding that she hopes will, I imagine it's about dollars. I imagine she's hoping somewhere along the line, this will generate dollars. Alicia asked, what the hell is even Substack? Substack is, I don't use it, but I know it's like this forum. I think a lot of journalists use it where you can self-publish your own writings and people can subscribe to that. So you can have subscribers who want to hear your kind of personal newsletters. And I imagine she's going to get on there and start to submit stuff. And you know what? The sad thing about it, she will get subscribers. She probably will generate money just out of people who are fascinated with the train wreck that is her life. So great question, Alicia K. Mayo from Tennessee. Always love hearing from you. You have made my Sunday once again. All right, let's move on. Captain Rhett Snuggler, thank you so much. Welcome aboard. Appreciate it. And Krista Johnson just gifted memberships. That's very, very sweet of you, Krista. Thank you so much. Appreciate it. All right, let's get on to our next question here. Oh, hold on. It's thinking. I might have to refresh it. Give me a second.
Hey, Joshua and everyone at the Courtroom Confidential team. My name is Robin. I'm calling from Ontario, Canada, and I am a big fan of the channel. I never get a chance to catch the lives, but I always watch them later. My question this week is about the judge, Jeffrey Ferguson, who is standing trial for the shooting of his wife. My question is about what happens to his previous cases that he has been a judge on, or does something happen to those convictions or sentences or decisions that he's made? And is there any recourse for the people involved in those cases to appeal, given the fact that the judge in their case turned out to be, or could potentially turn out to be, a convicted felon? Anyway, thank you so much. And I look forward to seeing this week's episode. Thanks. Bye.
Thank you so much, Robin from Ontario, Canada. Hello to Canada. Great question. So this is about Jeffrey Ferguson. If you guys have not followed that case, really, really fascinating case here out of Orange County, California. This guy, gentleman right here, was a judge for over a decade or more. Before that, he was a prosecutor. And from everything I read, had a really good reputation. People liked him, exemplary in his community. And him and his wife, I don't know if they were suffering from marital troubles or just, you've been married long enough and you're going to have your arguments here or there. Unless you're Tiffany and I, in which case we never argue, ever. But they go out one night and they're having a couple of margaritas and they start to get into it and they're arguing about something that they've argued about many times before. And that was his children from a previous marriage and how she doesn't think that they're very appreciative of the things that they do for them. This is like, I imagine this story is repeating itself thousands of times over all over the country. Well, they get home and he at one point is making like a finger guns gesture towards her. And she says something about, why don't you pull out a real gun? And the story goes, depending on who you believe, he either in response to that pulls out a gun from his ankle holster and shoots her in cold blood, or according to him, and he testified, he believed that she said, why don't you put that gun away? And he takes it out of his ankle holster, tries to put it down on the table, slips and pulls the trigger and shoots her. In either case, his wife Cheryl ends up tragically dead. And the case recently went to trial and the jury deliberated for longer than it took to actually present the evidence. And at the end of it, they said that they were hopelessly deadlocked and it's going to have to be retried. And it was hung 11-1 for guilt. And I got to tell you, as a prosecutor, you get an 11-1 hang. I don't think I ever got an 11-1. I got 10-2. You get a 10-2, 11-1 hang. It is brutal. Because it all comes down to, in my view, jury selection at that point. It makes you just feel like everything that you did since the point that you swore that jury in was a waste of your time, because somehow somebody got on that jury that really should not have been there because they were so dug in and never would have compromised. So that wasn't really your question, but that's all the background of this story. But Robin's question is, he's a judge. What happens to all his cases? What happens to everybody who he's ever presided over? The answer is this. I think there are a lot of defendants who are likely sitting in jail or have been convicted. They're having those conversations with their attorneys. And I think those attorneys are all telling them, unfortunately, there's not much we can do with this. Because this isn't like he's been convicted of a 20-year-long fraud scheme where he's been evading taxes, where he's been taking part in some sort of, where he's been addicted to drugs, where he's been involved in prostitution, some sort of ongoing demonstration of moral turpitude that you could say, while he was presiding over my case, he was also trafficking drugs. He was also stealing from the government. And therefore that affected his ability to be fair and unbiased in my case. This is a standalone anomaly in the man's life that occurred on an evening unrelated to any case he ever presided over. I don't think these people are going to get much traction out of it whatsoever, but it is fascinating. I guess it just demonstrates that anybody can find themselves in trouble. I feel awful. I feel awful for everybody. This woman lost her life. Children lost parents. And now this guy, living a life that I think a lot of people would applaud in one evening of either call it stupidity or carelessness or whatever you want to call it, ends the life of his wife and is now looking to go to prison for the rest of his life. Idaho Spud Girl, good to see you, says, does the judge lose his law license or just suspended? He is currently suspended because, again, it comes back to kind of that Casey Anthony point. If he's acquitted, he should be able to enjoy the full benefits that he had before. Now, what will likely happen is even if he's acquitted, I imagine the state bar and the judicial ethics committees will do their own independent investigation. And because they deal with a different standard, could say, well, you've been acquitted, but we feel that, the use of a firearm along with being intoxicated or whatever else, we're going to remove your license. We're no longer allow you to practice. We're no longer allow you to preside as a judge. But my understanding right now is that his status is just currently suspended, not like terminated. Fascinating case. And it's going back to retrial quickly. Judge Hunter, great Judge Eleanor Hunter. She was also in major crimes. All these big judges and prosecutors you've ever heard about have in Los Angeles have nearly all come out of major crimes. Eleanor Hunter is presiding over that case in Orange County. So they had a LA County judge go down to Orange County to preside over it, given the fact that he was an Orange County judge. And she reset it for trial like quick, like I think like April, May quick. So it could be coming back right away, and we will keep an eye on that case. But great question. Thank you so much, Robin. All right, let's move along now to our next case. Please tell me you can hear this.
Hi, Josh, and the rest of the CC crew. This is Louise from Birmingham, England. I'm also known as Enchanted Paws on your site. Just love your show. And I can't generally be live on a Sunday fun day because of the time difference, but I do enjoy watching it back. I just have one question. It's not trial related or lawyer related. Just one random thing. What is your favorite food, Josh? Thanks. Bye.
Love hearing our international folks. Louise from Birmingham, thank you so much for the question. What is my favorite food? Well, I will tell you, the first thing that immediately comes to mind is my mother's lasagna. My mother was not Italian, but she could whip up a lasagna like you would not believe. I challenged anyone to find a better lasagna from any restaurant. And it was one of my favorite things when she was still cooking to have her cook. If I'm cooking, though, which doesn't happen anymore because when you've got 3 little ones in the house, you don't even have time to breathe, let alone sit in a kitchen and cook. I do enjoy cooking, though. I like to make braised beef short ribs, where you really long cook it and you sit there and it takes hours and you create the sauce and all of that. We're talking about several hours in the kitchen listening to music and enjoying yourself on a Sunday. But again, if I'm not sitting here in front of you guys, I'm dealing with my 3 little critters chasing them around. But that is a great question. What are your guys? Send them in the comments. What are your guys' favorite foods? I can't think of something that's like my aunt makes a mean lasagna. Now I'm hungry for it. We're gonna have to have a lasagna off future. See, I don't even know what my mom did that was so much different. Maybe it was just the pure comfort of it, but it was It's one of my favorite things in the world. And she, unfortunately, is advanced in years and has not made it in a while. Krista says, my dad's homemade chocolate cake was bomb. I'm not a fan of chocolate cake, though. Yeah. Sometimes when a person just has that one thing that they make that they can continue to go back to and knock you on your socks for. Josh is an amazing chef. Oh, thank you, sweetheart. He makes a full day. Yeah. I'm not like the quick whip it up. I'm the like, okay, I'm going to need a good 6 hours of you to leave me alone while I put this thing together. But like I said, it's kind of therapeutic to me. Put on some music, start cutting up vegetables and slow cooking everything. I really enjoy that. But great question, Luis from Birmingham. Thank you again to everybody across the pond who joins us on this channel. Love to hear where everybody is from. All right, let's move along to our next question here.
Hi, Josh. Thanks for taking my call. I have two questions. They both have to do with the bar. And one is, what is your take on the situation with the California lawsuit against the organization that administers the bar exam there? And then secondly, if you have any thoughts, I'm not asking to be political or anything, about the ABA being asked to dismiss their DEI programs and how you might think that would impact new lawyers taking the bar. I ask because my husband is a 58-year-old 3L who will be taking the bar this summer. So thanks for your help.
Thank you, Valerie. First of all, absolute kudos and congrats to your husband. She said, if you didn't hear it there at the end, that her husband is a 58-year-old 3L, means he's in his third year of law school and going to be sitting for the bar soon. I love this. I love these types of stories. And I had Kaylin look this up because this is one of my favorite quotes of all time. And this is a Chinese proverb, I believe. The best time to plant a tree was 20 years ago. The second best time is now. And I love that because here is Valerie's husband, probably wanting to have been a lawyer for many, many, many years. And as the years go on, you could easily convince yourself it's too late, it's too late, it's too late. And I remember hearing from a woman speak at kind of like a motivational seminar or something that I had been to, and she became a doctor late in life. I don't think she even got her ability to practice medicine until her mid to late 60s. And many people asked her, what are you doing? You're not even going to be able to practice medicine for all that long. And she said, and she had not gone to, I think the story too was she had not even gone to college when she set out on this adventure to do this. So she was looking at 4 years of college, 4 years of medical school, however many years of residency before she would actually be a practicing physician. And she said, I could be, let's say it's 10 years down the line. I could be wishing that I were a lawyer, a doctor in 10 years, or in 10 years, I could be a doctor. And it was this idea that it's like that 10 years is going to come and go. Regardless, time marches on. And you could either be that thing that you always dreamt of being in that amount of time, or you could still be wishing that you were that thing. And so 58 years old, a 3L, God bless. You wanted to do that. I fully appreciate that. Yeah, maybe the best time to plant that tree was 20 years ago, but the second best time is right now. And I'm so very appreciative of you doing that. Maybe the best time for us to start a YouTube channel was a few years ago, but we started it now, and I'm glad that we're on this adventure. I think you can apply that to anything in life. Just instead of kicking yourself for waiting, just plant the tree now. Great question, and a congrats to him. But she asks about this lawsuit against the bar. And I had heard about this, but I had to look this up. This was an absolute dumpster fire, hot mess situation that took place with the bar here in California. First of all, the bar in California is one of the most difficult bars in the entire country. It's actually gotten easier. When I took it, it was 3 days long. Now it's 2 days long. The pass rate used to be below 50%, and now I think it's a smidge above 50%. If I'm wrong on those facts and figures, somebody's going to correct me, I'm sure. But they just got new, a new service was being acting as the administrators of the test, and new software to do that. So you go in to take the test, and they were going to do it as a hybrid remote and in-person test. And you have to download this software onto your computer, and it has to work properly. And I remember even back in the caveman days when I took it, it was a stressful situation to make sure that you had this software loaded correctly onto your computer so that you could take the test and not have any problems. Well, people go to take the test. They're having problems logging on. The program is crashing constantly. The site is not working. They're getting error messages. And it was a complete and utter mess. And now they're all told that they have to retake the test in March. And you might be thinking to yourself, well, that's okay. They took it. This was for the February bar exam. Okay, they took it, but they're not going to have to wait long, and they'll just take it again. And that's unfortunate. But here's everything that goes into this. First of all, you study for about 3 months straight. When I studied for the bar, it was like the only time in my life I wasn't working. I took off from a job. For 3 months straight, you treat your job 8 hours a day if you're being kind to yourself, 5 days a week if you're being kind to yourself, studying for this one exam. And then you get down to one moment where you're hoping you perform at your absolute best. And if it's not stressful enough to know that the last 4 years of college and 3 years of law school have led up to this moment, your jobs are all waiting on you. You've now interviewed for, are waiting. I was at the DA's office, and the only way I was going to get hired was if I passed. All of your acceptances are contingent on you passing. So if you don't pass, that just derails your life. You're talking about waiting perhaps another year. You're talking about studying again, taking the exam again, hoping that you get another job. And then the exam itself is so heavily timed and stressful that the slightest little things can set you off. I mean, I've heard stories about people having near meltdowns because of computer issues. And so to know that something like this took place, I can absolutely sympathize with people. We'll tell you a story. They tell you when you go into the bar exam that there was a couple of things that stuck with me. First of all, like I said, when I took it, it was 3 days long. They said that most people fail on the third day of the exam. And what they meant by that is that most people are passing through days 1 and 2, but they give up hope. They've convinced themselves that they failed. So by day 3, they kind of give up, and that's the day they actually fail. Whereas if they had just stuck with it, by day 3, they would have passed. The other thing that they tell you is that 50% of people are not passing this thing. So you got to think, if you're sitting there, the person to your right, if you're passing, they're likely not passing statistically, right? So, but that's the way that you're kind of thinking about it. And I remember, like I said, when I took it, the middle day of 3 is a complete, all day long, it's multiple choice. 3 hours in the morning, 3 hours in the afternoon of multiple choice. And I'm filling out the bubbles, and I'm going through, and we're maybe an hour and a half in. So I look, and I'm about halfway through. I'm doing fine. I look over to my right, and I'm not cheating, but I just glance at this poor gentleman's Scantron sheet just to see how far along he was. And he's only about a quarter of the way through. And my first thought was like, oh, that poor bastard's behind. And then my second thought was, yes, that means if he's failing, that means I'm passing. And that is a horrible, horrible way to think about it. But it also gave me enough motivation to be like, all right, if the odds are true, I'm going to pass if this poor gentleman's failing. Let's keep going with this thing. But anyhow, great question, Valerie. Yeah, hot mess of an exam, but I love to, I'm so much more tickled by the idea that your husband is going to be taking the bar exam, at 58, 59 years old, and I wish him the absolute best. Is that here in California? I'm curious if Maureen's on here, if she hears this. I'm curious if that is in California. Sounds like it is if she's asking about the California bar. Anyhow, let's move on to our next question here. Oh, are you guys hearing that? Vey.
Hi, Josh. This is Maureen in Monterey again, and I have a comment. You don't have to play it if you don't want to. It's just a comment. I was thinking that Donna Adelson made her attorneys hold that bond hearing because in the off chance that it was successful, my thinking is that she was probably she and her husband Harvey were probably going to unalive themselves. You know that she had thought about doing that before. She'd said that. And I think if that happened, she would achieve 3 things. She wouldn't have to live the rest of her life in prison. She wouldn't have to worry about her husband being left alone without her to care for him. And she would ultimately deny justice for Dan Markel, a man she absolutely hated. Anyway, that's my thought. I absolutely love your podcasts. You do great work. Thanks a lot. Bye-bye.
Thank you so much, Maureen from Monterey. I know that wasn't a question, but I think you're saying something that a lot of us have felt and echoed about Donna Adelson, that I agree. I agree that I think that option number 1 was to go to Vietnam. And having been stopped on that, I agree with you. Had she been presented with the opportunity, she may have taken her own life for all the reasons that you state. And, I think she knows just about as well as anybody else that the walls are closing in on her. And this is not going to go well for her. So great question. But I think that there are many folks who agree with you, including the judge. And I think we have another question about that coming up. So let's talk a little bit more about Donna with our next question here.
Hi, Josh. This is Pam calling from Michigan. I have a question for you. In the judge's response back to Donna Adelson in the denial of her bond, he cited quite a few legal arguments. My question is, does he look up all these? Does his court staff look up all of these? It was so nicely stated and very, I guess, eloquent in the fact that he just knew exactly what to say, how to say it, and I think shut down any possible appeal in any of this decision somewhere down the line. So I just, with all his busy schedule and other cases I'm sure that he has, where does he find time, or does legal staff help him with that? Thanks again for your show. I think it's great. I love listening and can't wait for Sunday Fun Day. Have a great day. Thanks.
Great question, Pam. I get this question a lot about judges. This is again in the Donna Adelson case. This is Judge Stephen Everett. He's fantastic. Crazy Mom RN says love him. I love him too. He's really, really good because he's got everything you want out of a judge. He's got a good, calm demeanor. He makes his decisions with authority. He's well researched. He doesn't get caught up in kind of the chaos of everything. I'm not saying it's an easy job being a judge. I think it's very difficult, but the good judges really do shine. and they really do distinguish themselves, and he's one of them. But she asks about what are they doing? How do they come up with all of this? Are they just back in these darkened judges' chambers with hundreds of books researching law at all times? And the answer is obviously no, but a little bit of yes. First of all, most of the very good judges I know are incredibly well researched, and they keep on track of the law. Now, there are publications that send them updates on the law all the time. And if they're a good judge, they're keeping track of these updates, and they're making sure that they are well researched on the current landscape of the law. They're also incredibly experienced, and they know the law. The other thing I'll say too is that a lot of these decisions that judges are making, we're not reinventing the wheel for the most part. We're dealing with areas of law and case law that we've been dealing with for a long time, and they can go back to that same well again and again and again. But do they have help? Absolutely. They have research attorneys who are attorneys. They have passed the bar, who are just basically, I don't mean to be diminutive, but they're glorified law clerks that just do the research for the judges in these incredibly complex cases with a judge with a huge caseload. They will do all the research on it. They have law clerks, an army of them sometimes, who are researching all of the little ins and outs of each of the questions that come before the judge and helping the judge brief it, often helping the judges write some of these opinions and rulings. But a good judge will go through that themselves with a fine-tooth comb. The other thing that they have is stuff like this. And this was a manual that was used quite a bit when I was a prosecutor. This is Levinson and Richard Dooley's California Criminal Motions. There's just kind of cheat books out there. There's books with you've got a subject, you've got a topic that you're not quite sure of. It will, by topic area, allow you to, okay, we're talking about search and seizure. Let me turn to the search and seizure section. And here's all the current case law. And here's the way that it's been argued before. And here's you not reinventing the wheel. And what's so great about this book is I know both of these authors here. So Levinson is Lori Levinson, who you may have heard of. She's a very famous, she was a federal prosecutor, but now she's a professor over at Loyola. I went to Loyola Law School. She's fantastic. She's quoted all the time, in news publications and goes on TV. And she's seen as a leading mind in the criminal justice world. And her co-writer on that is Judge Alex Richard Dooley. Richard Dooley was a judge when I was a prosecutor as well, and I appeared in front of him many times. He's also a brilliant man. He now sits on the appellate division here in LA County. So the two of them get together, and every year they update their I don't know what you want to call it, their treatise. And every year somebody, the attorneys all over the country will order that again, so that they have the most up-to-date version so that they can write these motions, and the judges have all of those resources as well. But that's how they do it. Nobody's back there just kind of, it's rarely is there this exhaustive amount of research that goes into finding these cases. Most people know the big cases, and if there is a complex and novel issue, they've got a team of people working for them that can help them look it all up. Not to mention, the attorneys are submitting briefs themselves, which might expose the judge to some of this case law. But great question, Pam. I really appreciate it. All right. Afton says, can judges be disciplined beyond being overturned on appeal if they do something egregious? 100%. There are judge ethics panels, and they can be, they could be disbarred. They could be kicked off. They have to do something really, really bad. Usually they're kind of protected, but yeah, they can be disciplined, but it's going to be for something far worse than a bad demeanor or bad, a ruling that people don't agree with. They're going to have to pretty much show that they violated some pretty serious ethics obligations. All right, let's move on to our next question here. Hold on, I want to make sure. I thought I didn't want to miss a question that we had. Oh. let me see. Redondo, 100% of burden proof is tough to get when the police like El Segundo don't do their job. Investigate the lazy prosecutors like Nathan don't do their job either. I'm a little salty. I can tell that you are Redondo. I'm sorry for everything that you're dealing with. Redondo again says, this is great to hear because I'm 52, waiting to hear if I'm getting into law school. Again, plant that tree now. Appreciate it. I hope you do get in because it sounds like you've got some bones to pick with some prosecutors and law enforcement folks. So I wish you the absolute best with that. And then Larissa Harris, thank you again for the question, says the Idaho 4 case, is it typical in a DNA case to not have any of the sample for DNA defense to test? Also, since IGG not coming into trial, to me, this is trial based on lies, was touched on in last hearing, probably has to do with jury. This is a great question, and we're going to get to, I know that we talk about the Kohberger case later on, so forgive me, Larissa, we will get to your question, but we're going to do it in just a moment. But thank you guys so much for the questions as we go along in this thing. Have you ever had to fight against judicial bias? This is Oh My Cologne did it. If so, how did you handle it? Judicial bias. I've had judges who I thought were absolute dog poop. Sure. I've had judges who I felt were just awful. And you deal with it. I mean, hopefully sometimes you realize that going in and you can, what's called paper that judge. You get to challenge that judge one time for no reason whatsoever. And if I know a judge is just garbage, I will challenge them. But sometimes you don't know, or sometimes they turn that way in the middle of the proceedings. And I've had judges who've done, I think, incredibly awful things. And it's probably one of the most frustrating things that you're ever going to deal with as an attorney, when you're at the mercy of this person that you feel is just unqualified and unfair with what they're doing. But here's the thing. You got to put your head down. You got to handle it. You got to get through it. You've got a client who's depending on you. You're the prosecutor. You've got victims who are depending on you. You got to put your head down and get through it. As a prosecutor, there's one case that came to mind. I sat in front of a judge. I'm not going to name that judge. I would love to name that judge, but I sat in front of a judge who was just awful. And it would, every single day, I would come back from court just kicking the dirt with just frustration. And I remember my supervisor was like, listen, you got to pull this together, because you got to get back down there. You've got a sworn jury. You've got jeopardy attached here, and you're just going to have to deal with it. And it made an already exhausting experience that much more exhausting. But if your question is, do you challenge these people? Can you get them kicked off? No. Unless this person says something flat out racist from the bench or something so egregious, there's not much that you can do about it. It's a very frustrating situation. The one thing that will happen sometimes, I know I'm on a bit of a tangent here, but if a judge has demonstrated a clear problem and bias more than once, the DA's office or even the public defender's office will do what's called blanket paper in that judge, meaning that everybody who gets assigned to that judge will object to that judge. And then the supervising judge realizes something's going on. And then they have a conference and they say, what's going on with this judge? And then we go, that judge is hot garbage, and we'll tell you why. And then they can talk to that judge and maybe get something corrected, because they don't want to have that judge become useless to them, that no one will go to them for trial. So maybe in extreme circumstances, something like that can happen. But judges can be very bad. They're just like anybody else. Thank you for that. How do you challenge a judge? What does that mean? Is there a boss above a judge? I think we even have a question on that today. I think it's our next question, to be honest with you. So let's stick with Lori's question and get to our next question here.
Hey Josh, this is Chris from Chicago. Just want to first say that you guys do a great job with this show. It's quickly become one of my favorites. My question for you is, do judges have a boss? And I guess what I mean by that is, does anybody hold judges, and I might as well just say I'm talking about Bev, have somebody that they have to be responsible to? Like, is there someone that holds them in check that if they do something wrong or they just seem like it's not going, unethical, I guess is the word I'm looking for? Yeah, do judges have a boss? I guess that's my question. Thanks, Josh. Doing a great job.
Thank you so much, Chris from Chicago. Love Chicago. I lived in Chicago for 4 years. I don't know if I've ever told that story, but I will someday. The 4 coldest years of my life, but I loved it. So hello to Chicago. And I forget who else had the question, but it was a similar question of, do judges have a boss? What do we do with these judges that are problems? Yeah, Lori, how do you challenge a judge? What does that mean? Is there a boss above a judge? So here's the thing. Like I said, almost every jurisdiction allows for some sort of a way to challenge a judge. In California, where I practice, you can either what's called paper a judge. You file what's called a 170 objection to them for no reason whatsoever, but you can only do that once. And it's not per judge, it's per case. So you better be very careful with it, because if you get a bad judge early on and you paper that judge, you could get a worse judge later on down the road, because they sometimes hop between judges. You go to one judge for arraignment, another judge for prelim, another judge for trial. You better make sure that there's not some judge in the hopper that you like even less. But you can challenge one judge per case, but you can only do that when you're first assigned to the judge too. So you can't be in front of that judge, have that judge make a bunch of BS rulings, and then say, I'm going to challenge you. You're done. You've accepted that person by the time you're sitting in front of them. So you got to be very strategic about this. You can also challenge a judge for a clear, demonstrable bias. But that has to be something along the lines of a judge saying, I don't like your client. I don't like the race of your client. I don't like clients who are accused of doing certain things. I mean, it's got to be awful stuff. Rarely ends up happening. I've maybe been a part of doing that once in my entire life. And then in these situations, when you challenge a judge under that, it goes to another judge who then decides whether or not that bias actually exists. And by the way, guess what happens? If that judge feels that your objection is not well-founded, you go back to the first judge. So now you're sitting in front of a judge that you've told the entire world you think is unfair. How do you think that judge looks at you? Okay. Now, but Chris's question is, do the judges have a boss? Yes, they do. They have a supervising judge. These are all set up in hierarchies. They all answer to, depending on your jurisdiction, but usually it goes up from, kind of a branch supervisor and then maybe the overall supervisor of that entire county. In Los Angeles, the presiding judge over all of Los Angeles is a gentleman that you might recognize. That is, I'm waiting for Kaylin to cue it up here. There he goes. Judge Rick Ocampo, my good friend, the prosecutor from the Keven Graff case. There we are together. I don't know why my face is so red, but there we are together. He was being honored by I think it was like the Asian Pacific Bar Association. He was being honored. He's a fantastic guy. And he was a prosecutor in the DA's office. And then he became a judge for many, many years. And then he presided over really heavy duty cases. And then he became the presiding judge of the criminal division. And now he is the presiding judge of all of LA County. So he is the boss judge of LA County. So every judge that gets complained about, that has someone object to them, whatever, he's going to hear about it. But I think your question is more about how do you get these judges in trouble? What do you do when you've got a judge that you feel is a wild card and is doing something that you either feel is unethical or biased or whatever else? Here's the thing. Unless that judge demonstrates some sort of clear bias. Not they seem to be ruling in favor of one person, but they're ruling in favor of one person with no basis for it. In other words, the law dictates they do X and they do Y every single time. And you can imagine how difficult that is to show, because many times these judges are making calls that can be considered close calls, and you may not agree with their decision, but their decision is based on something, based on some sort of case law, based on some sort of reasoning. So when it comes down to, I don't agree with your reasoning, that's much more difficult. And you're never going to get a judge to say that their reasoning is based on something improper. So you can imagine how difficult it is to actually show that a judge has been demonstrably biased. The other thing is, we don't want judges to be constantly called to the principal's office by the supervising judges, because we don't want that judge to then become the fiat ruler of the entire county, right? Each of these judges should be independent minds and should be judging based upon their own discretion and interpretations of the law. Otherwise, then everything's just going to have to be okayed by the supervising judge. I guess this is my long-winded way of saying, if you guys find yourselves frustrated by judges that you're watching and you feel like they're a problem, welcome to my world. It is the probably biggest slap in the face by reality that I ever got as a young attorney. Is you come out of law school thinking, wow, a judge, and they're wearing that black robe, and God, they must know what they're doing and how they're doing it. And boy, do you quickly realize how many of them are just absolute hot mess, and you wouldn't let them run a lemonade stand, let alone run a bench, and somehow they found themselves there. I could tell you stories that would make your toes curl with some of the horrible things that judges have done, and some of the incredibly disqualifying judges, I think, that are sitting on the bench. Now, they're rare. It's not a lot. It's very few. The vast majority are good to great. But there are a handful, and enough to make you scared of judges who just really don't deserve to be there. And you just have to learn to deal with it. And then if you get to be as old as I am, a lot of your buddies start becoming judges. I've got, not just Rick and Walgren and all these guys who were my kind of mentors becoming judges. I'm talking about guys I went to law school with, guys I was prosecutors with, are now sitting on the bench. And talk about walking into a courtroom and having your buddy sitting there in a black robe trying to tell you what to do, and you're looking at him going, I know you, dude. I've seen you puke in a toilet after taking too many shots. So don't try to tell me, XYZ on the law. That's a real experience when you start to realize these guys. But I will tell you this too. It's a fun experience when you walk into a court and the judge has to make a disclosure that he has a personal friendship with you, and you're sitting there with your client for the first time, and he thinks like, oh, I made a good decision in hiring this guy. Anyhow, fun stuff. Great question from Chris. Great question from everybody. June Sidlaka says, can a pro se vice bring a charge of bias to a judge? I'm talking about Alan Jackson. Oh, can he make a challenge against her? I can't see why he can't. And I think what you mean is pro hoc vice, but he absolutely could, or Yannetti could, and I imagine that they will. But at the same time, what is that quote? When you come for the king, you better have a kill shot, or whatever it is. I can't remember, but it's like, if they're going to raise a charge of bias against Judge Cannone, they better win. Otherwise, they're going right in front of her. And if you thought she was bad before, buckle up. So I imagine they're keeping their powder dry. They're just putting their head down, trying to get through this, trying to deal with it. And if the opportunity presents itself down the line, maybe they'll do it. But I'll tell you this, as frustrated as you guys may be watching this, and I know not everybody agrees on this, but I know that a lot of people watching that trial are frustrated by that judge. Alan's been through it before. We've all been through it before, and we've been through it far worse, and you just deal with it. You don't like it. You gnaw your teeth and punch your pillow, but you get through it. Mama She, thank you so much for the super sticker. Always a pleasure to see you. All right, let's get along here to our next question. These are so great. You guys are so fantastic. I love you all. You just do the best questions.
Hi, Joshua and T-Seals and all the gang. This is Black Witter in the Republic of Ireland. I just getting ready to go out to the beach now for a cold blast of air. I just wanted to say I'm really glad about the text messages coming out from the surviving roommates in the Idaho 4 quadruple murder, because that poor girl VM, things people have been saying about her. I lived in a similar kind of a house when I was at college, probably a bit more crazy, but no one died. I just can't imagine like that happening and how you'd cope with it. Like, it's just too huge, you know. So that poor girl's been driven to the dirt, and I hope that people will be kinder to her now. And hope you all have a great day. I'm going out to the beach now. Take care, everybody.
Black Witter, fan favorite. Thank you so much for leaving a question. Everybody loves to hear it. I can see everybody in the chat going wild. We love to hear from Black Witter from Ireland, where my friend Arthur Leahy is from. I'll have to tell you a funny story about Arthur Leahy one day. Anyhow, great question about the text messages on the Idaho 4. So this got a lot of attention because they're now starting to release the text messages that were exchanged by the surviving roommates. And this is on the Bryan Kohberger case, obviously, and the 911 call. And I'm kind of shocked because I've seen a lot of reactions from people online, and I know Twitter is no great representation of what people are actually thinking, but you do see a lot of people reacting. And there was a lot of people who were kind of, I don't know what's the right word, critical, aghast, shocked, whatever you want to call it, about the response of these two surviving roommates and how they handled this situation. And I love that Kaylin put this up, that we always kind of want to remember the victims in this: Ethan Chapin, Kaylee Gonzalez, Zaina Kernodle, and Madison Mogan. Beautiful kids who lost their lives way too early. But let's go back to this, the graphic, Kaylin, of the text messages. And I want to, can you make it a little bit bigger? So this is, yeah, here we go. There we go. People have been walking through this and talking about it and asking questions, and, you know, what possibly were these kids thinking? And, you guys can read through it, but they're talking, they're obviously panicked, and they're saying, what's going on? I saw a guy wearing all black. I'm freaking out. They're trying to contact their friends and everything. And then people are saying, but wait a minute, they didn't even call 911 until, what was it, 11 a.m. the next day. So they go through this horrible, horrible experience. They see somebody in the middle of the night. They can't get a hold of their friends. And then they don't call 911 until the next day. And then the next day, the 911 call is even bizarre. They're not talking about a bunch of blood. They're not talking about our friends have just been murdered. They're all confused. They're saying they got too drunk. Now they're not waking up. And it's just, I will admit fully, it's bizarre, right? It's not, put it to you this way. The best way I think to describe it is it's not how I imagine I would behave and act in that situation. And I think that's what a lot of people are doing, is taking a look at this and saying, that's not how I would behave or act in that situation. And Krista says, in my opinion, they were scared for their lives. and I agree with you, and I'll go even one step further. They're college kids. They're living lives, if we can put ourselves way back to that time, they're living lives very different than the lives we all live now. If I woke up in the middle of the night now and I saw a man walking through my house with a mask on, I'm not going back to bed. I'm first of all grabbing about as many guns as I could possibly find. Secondly, I'm screaming bloody murder. Third, the cops are going to be there. Fourth, there might be dead bodies and it's not going to be anyone in my family, right? Like, we all know how we would react now. But place yourself back to being in your early 20s and you're in college, and I don't know what your college was experience like, but a lot of people had a college experience where they're living in these houses that are like party houses. And, you know, it's a bunch of people living in the same house, and people are in and out of that house, and they're in and out of that house at different hours during the day. And they're in and out of that house at different levels of intoxication. And waking up in the middle of the night and seeing some stranger is not something that sets off as much alarm bells as it does for us as adults. And your friends not answering their texts in the middle of the night is not something that sets off as much alarm bells as it does for us, because that friend might be drunk and they'd all been out drinking and they all didn't get home till super, super late, and they're probably all highly intoxicated. All of that. Yes, it's strange. Yes, it's bizarre. Yes, I feel like I would have acted differently, but I also don't know how I would have, as a early 20-year-old, reacted to this situation. And I want to tell you a little story. It's not my story, it's Tiffany's story. And she gave me permission to tell this story, but I think it's really instructive for this kind of conversation that we're having. And Tiffany's going to get angry because I'm probably going to leave out the best parts or not get the story right. But in her early 20s, Tiffany, during college, was living in a house that was very similar to this house. She said it wasn't like a party house per se, but it was a house where a bunch of college kids lived, and they would have parties there, and people would be in and out of that house at bizarre hours in the night. And it was a house, too, where they had made living spaces out of non-traditionally living space rooms. So, you know, you've got your living room has been converted into another bedroom so that more people can live in this house. We all know these types of houses. Also, it was a house where there was an addition added onto it. So she had a window from her room to a neighboring room. There was a window, but it was always kept shut because it used to be a window to the outside, but now it was a window into another room, right? But that window was always kept shut and the shades drawn to give everybody privacy. Late at night, Tiffany is in her room and she wakes up to someone walking through her room wearing a hoodie with a flashlight. And her first instinct is that is her roommate. And she's actually appreciative that, if she's going to be up this late at night and she's looking for something, it's good that she's doing it with a flashlight rather than turning on the lights and waking me up. And instead of waking up and saying hi and interacting with her, she kind of rolled over and pretended that she was still asleep. And she said, too, that she had been fighting with that roommate earlier in the day and just kind of didn't want to get into it with her, didn't want to talk to her, didn't want to have any interaction with her. And the next morning, she wakes up to the police being at the house because somebody had taken a knife and slashed through the screen door of their home and had actually broken in. And that person that she saw walking through the room in the middle of the night wearing a hoodie with a flashlight was somebody who was burglarizing their home. And they had stolen a bunch of jewelry and stolen a bunch of computer equipment. And she had actually witnessed that person. And that person, she was in the same room with that person. Now, Tiffany will fully admit to you, yes, Tiff Knox says, oh crap is right. She will fully admit to you that had that happened later in life, she would have reacted differently. But she's living at a time where people are in and out of her home and where people are at different levels of intoxication, and you're just not behaving the way that you normally would. And you're also young and probably not thinking the way that you normally would. And that was a scary, scary situation afterwards. And I think we can all agree, and Tiffany will admit, she probably didn't act in a way that we would all consider all that reasonable under the circumstances. The other person living in the home who was in that room that was adjoining, that they shared the window, saw something and heard something in the middle of the night. But that person was enjoying themselves with participation in different kinds of substances, and thought, well, I'm being paranoid and I don't want to wake anybody up, and I'm just going to kind of ignore it. So other people in the home had to actually be aware of this person, and nobody had done anything. And that, to me, I think is a much more reasonable understanding of what these girls were going through. Did they respond in retrospect in a way that we find to be understandable? No. But did they respond in a way that is understandable for their lives at that age, in that time, in that home? I think much more yes. One other thing I will point out about this case, and I think this is fascinating. The 911 call is also confusing because the girls are saying, they're being asked, are they awake? And they're like, no, they're not waking up. They're asleep. And it's like they don't know. And that was one of the things that shocked me, is like, I mean, we're all to imagine, I suppose, this was a bloody murder scene. They've been stabbed to death. How are they not aware that this horrible thing has taken place? And they're on the phone saying, can you bring someone? They're not waking up. They got home drunk. They're not aware. You hear another voice, a male voice, during that 911 call. And at one point, you hear that male voice say, get out, get out, get out. And there was a statement released from the Gonzalez family that I want to read to you guys. We're going to put it up here, but I'm going to read it. And it says, as we continue to process the 911 call, we just wanted to share some of our thoughts. We stand together with all the victims of Idaho, both those we have lost and those who remain forever marked by a tragedy that no passage of time will ever erase. The 911 call, it is not the neatly rehearsed dialogue of a well-crafted story, not the polished performance you might expect from a Hollywood script. No, it is raw, it is jagged, a searing, unvarnished truth that no camera could ever hope to capture. Every breath, every cry, every tremor in the voice reveals a reality so cruel, so brutally honest, it cuts deeper than anything fiction could devise. After hearing that call, one thing is clear. Hunter, and that's apparently the male voice you hear. Hunter, with his quiet, stoic resolve, protected those girls from a nightmare that no one should ever be forced to witness. He stepped into the abyss, shielded them from horrors that will haunt him forever. For that, the Gonzalez family owes him a debt that words cannot repay. If you are expecting a neat cinematic conclusion, something palatable, something that offers closure, let's make this clear. The real world does not operate on such terms. The terror of that night cannot be cleanly packaged, wrapped in a bow, or distilled into a simple, digestible narrative. It is ugly. It is painful. It is the kind of horror that shakes you to the deepest core. These were not adults. They were children, still clinging to the fragile threads of innocence when the world was violently torn from them in an instant. In closing, let us face the uncomfortable truth. Had the 911 call been made the moment the accused left the house, it would not have saved anyone. Nothing would have changed. So we ask respectfully, please do not waste your energy pointing fingers at those who could not have prevented it. The anger, the grief, the pain, they must all be focused on one thing, one person, the one who stole the innocence of Moscow that night. We demand justice, and that cause is all that matters now. Incredible statement. I couldn't agree with it more. I think it's a sad state of affairs that they even had to make it. But one thing I think that we're learning from this is when they said Hunter, with his quiet, stoic resolve, protected those girls from a nightmare that no one should be forced to witness. He stepped into the abyss, shielding them from horrors that will haunt him forever. I imagine when this case plays out, what we are going to find is that Hunter actually prevented those girls from going into the room to see what he saw. And I think he went in there and realized what it was. The bodies in the bed were not just asleep. We're not passed out. We're not drunk. That something nightmarish had taken place. And he did not allow those girls to go in there and see that. And if that is true, what I'm kind of piecing together here, then that man is an absolute hero in my book. That young man is going to live with this nightmare for the rest of his life. And he's a saint for sparing them of that. Anyhow, wow, what a case. You can imagine the moments they were living through. Jody says, so heartbreaking, and I couldn't agree more. So Thank you, Black Witter. So great to hear from you. And thank you for leaving that question. All right, let's move along here. Hold on.
Hey, Josh and Tiffany, it's Shelley. I don't have a question, but I do have a request. I'm heading out your way in a few weeks. I mean, obviously, as I get off the plane, the red carpet will be rolled out and confetti and balloons will drop from the ceiling. And I'm sure you'll allow me the use of your limo and driver. But my request is that you arrange for the most beautiful weather while I'm there. Let me know if you need the dates. Seriously, just wanted to thank you, Josh, for your natural ability to explain things so simply. I learned so much every episode. And also a big thanks to Tiff for creating such a great community. I enjoy the chats so much, and Tiffany and Kaylin help keep it a safe space for us so we can voice our opinions and not get bashed by the ones who may have a different view. So big thank you to all three of you for all you do. Take care.
Oh, Shelley, that is so sweet. What a sweetheart. And thank you for Kaylin and Tiffany. You are the heartbeat of all of this. And I thank you again for bringing them into this. Thank you for the kind words. It's that kind of stuff that keeps us going. I hope you're not out here now because we had rain, but I think it's going to get better. Thank you again for being such a positive influence on this whole community. Great to hear from you. All right, let's see what else we got here.
Hey, Josh. This is Christina Evans. I have been lurking for probably a year now, watching you. I followed you over from, what was it, Crime Weekly? True Crime?
True Crime Daily.
Anyhow, my question for you is about Courtney Clenney. It seems like her defense is trying to make a really big deal about whether she threw the knife, which stabbed him and ultimately caused his death, or she stabbed him directly with the knife. And I don't see what difference that makes. I mean, in the end, she's the one who caused the injury and caused his death. And as far as I can tell, for no good reason. It's not like it was self-defense or anything. So I'm just curious about the defense trying to make a big deal out of that and what impact that could possibly have on the case. Thanks. Talk to you later.
Thank you so much, Christina. Great question. Great. See, this is the kind of thing I never would have thought to talk about, but it's a great question. So this is the Courtney Clenney case. She's accused of stabbing to death her boyfriend, Christian Ubumseli. It's a stabbing case, and Christina says the defense is going to be, and they've already kind of put forward some evidence of how this is possible, but the defense is going to be that she didn't stab him holding the knife. She threw a knife at him, and through some miracle of physics managed to stab him in a way that he lost his life. Now, she says, first of all, kind of an outlandish defense, but Christina's point is, what does it even matter? And I think that's a great question. Why does it even matter? Well, just from a purely kind of common, hit you in the gut perspective, I think that we can all agree it's far less horrible if she were holding the knife, stabbing him to death, than I'm in a fight with you, I hate you, we're fighting with each other, and I threw a knife at you, right? And this comes down to what kind of a murder are they charging her with here, and how would the idea of malice aforethought play into all of that? So I thought this would be a fun opportunity to show you guys how attorneys research this type of stuff. So I'm going to present to you. This is the California jury instructions that I'm using here. Hold on, let me make sure I'm doing this great. This is what I would do in this case if I were the prosecutor of this case. This is the the California jury instructions, CalCrim. So first we're going to want to take a look at murder. Okay. Oops. Is this not going to, I knew this was probably too fancy for me to try to do here. Okay. We're looking for instruction 520. Here we go. 520, first and second degree murder. Malice aforethought. What does that mean? So this is, if you're going to try this case, you pull, the first thing you do, pull the jury instructions, because this is the end result you need to get to, right? You need to be able to prove these elements to your jurors. So I don't care what kind of witnesses, experts, evidence you got. If you're not fulfilling these elements, you're wasting your time. So, oh, sorry, we missed that Kohberger question. Can we do that really quick? Tiffany just reminded me. Sorry, guys. Yes, I told you, Larissa, I would get back to this. Is it typical in a DNA case not to have any of the sample for defense to test? Also, since IgG is not coming into trial, this to me is trial based on lies. Was touched on the last hearing, probably. Okay. Couple of things here. Is it typical for if the DNA case to not have any of the sample for the defense to test? No, that is not typical. If that is what is being said here, that there is not enough for the defense to test, that, though not fatal, will be a problem and something the defense will actually bring up, I'm sure. Usually, when you're dealing with DNA, you have enough of a sample that you can give an untested, because when they test it, they do not destroy it, but have to manipulate it, but an untested sample to the defense for them to test independently. Here, because it's touch DNA and found on one very small part of the knife sheath, there wasn't enough. I'm guessing, though I haven't not read that exactly, but likely true. So the defense is just going to have to rely on the testing done by the prosecution. Is that fatal? Is that improper? Is that illegal? No, no, and no, but the defense can absolutely point it out. But here, my understanding is the defense is going to say, we admit that's his. We just say that it was planted there. That's my understanding going to be their new defense on this case. But the other question she points out is that they're not going to bring up the IgG at trial. That is another thing that we learned. They said that they're not going to get into, the prosecution, get into all of the IgG, but they're going to say that it was based upon a tip. Now, should we be losing our minds about that? I don't really think so. And here's why. All of the A through Z that got them to Bryan Kohberger, unless the defense plans on challenging all of that, it really is not consequential, because at the end of the day, it's his DNA. So all of that is much more of a legal question than it is a factual question. The jurors don't need to factually decide whether or not the IgG was properly done, whether or not they had probable cause, whether or not they did search warrants, whether or not the FBI should have been able to. All of that's legal questions. That's not factual questions. The factual question is, what does it mean that it's his DNA? Does that mean he was there? Does that mean he touched the knife sheath? Does that mean he's implicated in this crime? Those are the questions for the jury. All of this other stuff is questions for the judge. So if they're not going to present the IgG and they're just going to say it's based on a tip, essentially what they're doing is short-circuiting all of that for the jurors so that they understand there was some mechanism by which they led themselves to Bryan Kohberger. And after having been led to Bryan Kohberger, they were able to match his DNA to the knife sheath. And if the defense wants to say that the collection of that DNA was improper, that the testing of that DNA was improper, they can still do all of that. And if they want to say that that DNA was planted, they can still do all of that. But the how did they get to Bryan Kohberger is not a question for the jury, in my view. But I think it's a fantastic question, Larissa, and I thank you so much for asking it. And forgive me that we had to come back to it later. All right, back to class, back to my presentation here that I hope you guys are going to find enjoyable rather than boring. Okay. All right. So these are the elements. These are the elements that you're going to have to go back to. And the elements of what we're talking about here, this is what we're talking about. There are two kinds of malice aforethought: express malice and implied malice. Proof of either is sufficient to establish the state of mind required for murder. The defendant has express malice if she unlawfully intended to kill. So no one, I think, is going to say here, and the prosecution doesn't really need to say she intended to kill. Maybe they will. Maybe they say you stab somebody that many times, you intend to kill them. But there's even another type of malice that still qualifies for murder, and that's implied malice. And that is if she intentionally committed an act. In other words, fine, you want to say she threw the knife? She threw the knife. The natural and probable consequences of that act were dangerous to human life in that it involved a high degree of probability it would result in death. Can throwing a knife at somebody result in their death? Sure. Is the natural and probable consequences of that dangerous to human life? Absolutely. At the time she did it, she knew that it was dangerous. Do you think Courtney Clenney was aware that throwing a knife at someone could be dangerous? I think anybody above the age of my toddler would know that. And 4, she deliberately, with conscious disregard, did that. In other words, you knew it was bad and you did it anyways. That to me is implied malice murder. That to me is second degree implied malice murder, and that is likely the theory in which the prosecution is going to go after her for. And so, to your question, does it matter that she's holding the knife and stabbing him or throwing the knife? From the prosecutor's perspective, not all that much. Why does it matter from the defense perspective? Well, then we got to go to a different CalCrim instruction, and that is CalCrim 505. Let's see if I can find this one quickly. I spent my entire career doing exactly what you're watching me do right now. Just search through these things to try to find the right instruction, because they don't have a program for this, which you would think in our modern times they would. All right, come on. Where are we going here? Did I miss it? And by the way, when you're a prosecutor, you're not getting paid by the hour. So all of your watching me do is just a waste of time. Okay, here we go. Justifications and excuses. CalCrim 505, justified homicide, self-defense or defense of another. Okay, in order to prove this, here are our elements, 1, 2, and 3. The defendant reasonably believed that he or she was in imminent danger of being killed or suffering great bodily injury. Okay, if they're going to present evidence, and that might include her testifying that she was believed that Oban Sully was going to kill her. 2, the defendant reasonably believed that the immediate use of deadly force was necessary to defend herself against that danger. Again, if she takes the stand or they otherwise prove that she felt that she had to defend herself against him by using some sort of deadly force. And 3, the defendant, here's the kicker, used no more force than was reasonably necessary to defend against that danger. That's, I think, why the defense would much rather have her standing 10 feet away throwing a knife than standing right on top of him stabbing him with a knife. Because is the reasonable use of force necessary to defend against the danger? It's much easier to argue she was defending herself against danger in a reasonable manner by throwing a knife than by standing there and stabbing him multiple times. And I think that's what it's all coming down to. But to answer your question more directly, Christina, they don't got much more to work with. That's really what it comes down to. They're dealing with a case that's really bad. And so the best that you can do is start to create enough of these little questions that the jurors may get hung up on one of it. But end of the day, the guy's stabbed to death. It's going to be hard for them to get past that even implied malice murder concept. So you all receive an A for paying attention to Josh's class for today. All right, let's move on. Oh, what did I do? Now I messed everything up. Kaylin, I messed everything up. Okay. Here we go.
Hi, Josh. It's Tisha, and I have a question on this Sunday Fun Day What is meant when an attorney says the fruit of the poisonous tree? I'm hoping you can explain that to the layperson like me. Thank you.
See, did you guys think that we'd be talking about implied malice murder and fruit of the poisonous tree all within minutes of each other in the same conversation? This is why it's so great. Great question, Tisha. Thank you so much for contributing and asking this question. All right, well, this caused me to do a little bit of work. I've used this phrase dozens upon dozens of times in my career, but where does it come from and what does it mean? Fruit of the poisonous tree doctrine started from a case called Silverthorne Lumber Co. versus United States. It's a case from 1920. That's how long some of these concepts have been around. The Silverthorns were arrested at their homes and they were detained and they were in custody for several hours. And while they were in custody, U.S. Marshals went out to their place of business and ransacked the place. They did a clean sweep of all the documents, all of the papers, all of the books, not computers, because this is 1920, but they took everything. And it was found that that search and seizure was illegal. But prosecutors at the time said, fine, all the documents, all the books, all the papers were illegally seized, and we will return those. But we want to be able to use the information we gained by reading those documents against them. And the court said, no way. What are you talking about? Now, this is what's interesting. This is how our law works. We're on a common law system here. There's a law. The Constitution says illegal search and seizure is not going to be allowed. And therefore, if it is, we're going to exclude that evidence. Well, what does that mean about evidence derived from it? That's not in the Constitution. So now in steps the Supreme Court, and they make a decision, and their decision says, by the way, that includes things gained from that. 1920. That concept bounces around the courts until 1939 in a case called Nardoni versus United States. This was from a decision by the famous Judge Felix Frankfurter. I forget who was it that asked a question, but I'm sure that their husband, who is in his third year of law school, has heard of Justice Frankfurter many times before, so written some of the cases that we still talk about to this day. That case involved an illegal wiretap. They had wiretapped the defendant's phone, learned some information, and he said, quote, this: the burden is, of course, on the accused in the first instance to prove to the trial court's satisfaction that wiretapping was unlawfully employed. So the defendant has to say that wiretapping was bad. Once that is done, as was plainly done here, the trial judge must give opportunity, however closely confined, to the accused to prove that a substantial portion of the case against him was a fruit of the poisonous tree. And that's the first time that that term is used in our jurisprudence here. So in other words, you said that wiretap was illegal. Great. Now you got to prove that most of the information the government is using is derived from that or fruit of the poisonous tree. And then he concludes, this leaves ample opportunity to the government to convince the trial court that its proof had an independent origin. Independent origin may sound familiar to you because that brings us to the idea of a case from 1984 called Nix versus Williams. In that case, the defendant challenged the admissibility of evidence about the location of a body for violating his Sixth Amendment rights. In other words, he was either had counsel and asked for the counsel and they weren't there. Somehow, this person was interviewed without their lawyer or had asked for their lawyer and the interview wasn't stopped. And he gave information about the location of a body. And he was asking to have that kicked out because that was fruit of the poisonous tree, right? It should have been excluded. It was an illegal interview in violation of his Sixth Amendment rights. And from that, they derived information, and that information was the location of a body. The court held that the evidence was admissible because law enforcement would, quote, inevitably have discovered the body even without Williams' statements because a massive search had been underway in the very location where the body was ultimately found. So out of that case, from Nardoni in 1939, you see two of the biggest concepts we have in criminal law procedure starting their birth, from fruit of the poisonous tree to inevitable discovery. And I don't know if I answered your question, Tisha, but I hope that I did. Yeah, what does fruit of the poisonous tree doctrine mean? That's what it means. It means you don't get to benefit from doing a bunch of shenanigans ahead of time. But if you're the government, you do if you can show that you could have got there anyways. That's the long and short of it. Thank you so much for the question. All right. We only got a couple of more here, guys. We're coming to the end. Hold on. We got a question. Oh, hold on. Idiot Wind, that name. About guilt of the defense attorneys, just want to say this is one side going up against the state, each having zealous advocates, state with more power and often resources with grave consequences to accuse. Very true. I will say this, and I always bring this up. The resources of the state, I agree with you. The defense has to pay for everything out of pocket. The resources of the state, though, are often confined to the cops that they're given. So those resources are the detectives who happen to be working it and the medical examiners to happen to be working it. And are they always the best? Sometimes no. And I will tell you this, if you think that when I was a prosecutor, I had a team of law clerks and assistants and willing cops at my disposal at all times, have yourself another think. Because yes, I'm not paying for it out of pocket like the defense is, but in my view and experience at least, there was not a whole bunch of unlimited resources. Maybe on the federal side, not so much on the state side. But Idiot Wind, you are the best, and I appreciate you bringing up that point. All right, where are we at here? All right, make sure let me know you guys can hear this one.
Hello, Courtroom Confidential. Happy Fun Day Sunday to everybody. Great to see you all. I have two questions. I'll keep it simple. Well, with Kieran Reed anyway. So my question is, why is Auntie Bev, why doesn't she rule from the bench, as they say? So there were all these motions that went on, and then there was no answer, and then all of a sudden it just comes at the next day at 4 o'clock. I mean, what is that all about? Is that normal? Do judges do that often? Why would she do that? And then the next question is about that poor lost teenager in Punta Cana. Well, I think she's 20. To me, it's very much feeling like an accident. What do you think, Josh? All right, thank you. Bye, guys.
Okay. First of all, I didn't want to cut off Idiot when you had a second part to your question. Thank you again. It says, then the jury, having heard the evidence, decides that's vital to getting as close to the truth as we can. And we mustn't forget prosecutors are as liable to dirty tactics as any defense lawyer. 100% true. Just because you're a prosecutor and got a badge does not mean that it's beneath you to try to pull some dirty tricks. I would like to say, having shared both professions, those are rare that people would do that, but it does happen. But great points, and thank you so much for the contributions there. All right. Sonia says, why doesn't Judge Beverly rule from the bench? I think there's a few reasons for this. One, and this is in the Karen Reed case. One, it could be practice. I'm not sure how she runs her court normally. Some judges, that's just how they do it. They take everything under advisement and issue rulings. I am used to judges who rule as it's happening. I'm used to judges that you file your motions, you file your papers, you go into court, you argue it, and at the end of the day, the judge says yes or no, and they make a decision right then and there. She does not do that. And I don't know, one, it could just be her practice. Two, it could be that she really does keep her mind open to hear the arguments. And maybe these arguments have been incredibly thorough. And it could be that she wants to see if anything comes out in argument and she reserves her ruling on that. 3, I think it could be so that she avoids saying or doing something that will fall under the hypercritical microscope of this case and make her look foolish. And she might be sensitive to that and saying, I don't want to put anything on the record that I haven't thought about and written down so I know exactly what I'm saying. And 4, I think it could also be to avoid the media of all of it. That, you know, you make a ruling sitting right then and there, and it has a reaction, and people may want to argue further, and people may go outside and make press conferences about the whole thing. And maybe she feels that there's taking some of the heat off of all of it by issuing these rulings later. But I will tell you, I'm not used to it. I do find it to some extent frustrating. I do also find it frustrating that she will say she takes stuff under advisement, and then it seems like we have other hearings in between before she even makes rulings on those hearings we're waiting on. So a lot of stuff remains in this state of limbo as she's trying to decide it. But that's, you know, I have had judges who like to take things under submission. For the most part, the judges that I dealt with that would, it was because they were trying to be very thoughtful, and they wanted to put some case law in there and some reasonings. But I know that sometimes she'll take stuff under advisement and issue a very brief ruling. I think it's just more her practice, or at least has become her practice on this case. And then Sonia asked about the Sudiksha Konanki case. You guys have been following this, or if you haven't, here's a quick catch up on it. It's a case out of the Dominican Republic, the Punta Cana resort. Sudiksha here was with her friends. They had been out drinking till 4 a.m. There's a new video that has come out that shows that they were incredibly intoxicated that evening at the nightclub. They go back, all of them go back to the ocean, because that's a brilliant thing to do. And while you're incredibly intoxicated in the middle of the night, to go out to the ocean and unfamiliar waters. It sounds like they got into the water, her and this gentleman here who's now become a person of interest. Her clothes were found on one of the portable beach beds that were there. Her friends who were with her, they go back to their room at close to 6 o'clock in the morning. The man that stayed with her, who's pictured there, says that they got caught up in a big wave, that he was able to struggle out. He made it to shore. He immediately throws up and passes out. And when he wakes up closer to 9 a.m. in the morning, she's nowhere to be found. And the question is this foul play, or is this a horrible accident? And Sonia says, it sounds like it's turning out to be a horrible accident. And I agree. I think this is a horrible accident. I think that they were, you know how easy it is to drown in water like that when you're drunk, and when you're, you know, who knows how good of a swimmer you are anyways, and it's the middle of the night and you get disoriented and you're incredibly intoxicated, and you take one big breath of air and it's not air, it's water, and it's horrible and sad and tragic. Jury Duty Pod, Kimberly says, she's from my area. It's nuts here. The poor family. It's horrible. It's heartbreaking and tragic and horrible. And I hope they're able to find her. And I hope that you know, we're able to kind of put this to rest. But I do agree that all signs kind of point towards this being a tragic accident more than anything else. But thank you so much, Sonia. Always love to hear from you, for asking the wonderful question. And I think this is our last one, guys. Are you ready? You ready for the last question of the day? And who better to close us out?
Happy Sunday Funday, Joshua, Mods, and the crew. This is Alicia K. Mayo from Tennessee again. The other night, I rewatched Runaway Jury with the incomparable Gene Hackman. And while I do hope there are no paid professional jury consultants that have an entire team to dig into the life of any prospective juror, it got me to thinking, Joshua, what are your overall general thought processes when it comes to selecting a jury? And do you have any jury day rituals you follow, such as wearing a lucky tie, maybe using a particular pen, or some sort of, let's call it, game day ritual you do before jury selection starts? Thanks. Bye.
I love this question. Thank you so much, Alicia K. Mayo from Tennessee. I love this question. First of all, let me tell you about what jury selection is in most cases. In the cases that you watch on TV that are these really high profile, involved, complex cases, lots of times they will give them plenty of jury time for voir dire and jury selection. And it might take days, and they get through, they get to question these people, and they hand out questionnaires that are several pages long, and there's jury consultants and all that stuff. In my experience, the vast majority of cases are not handled that way. You are given an incredibly limited amount of time to voir dire people. It was not uncommon for the judge to give you 20 minutes to voir dire 40-something people in a veneer. What are you going to do with that? How are you going to learn anything about anybody when you've got about 30 seconds per person? And by the way, it always happens that one person answers more questions and takes up all the time. And many people you don't get to even talk to. They never even open their mouths. I don't know how many times I have sworn a jury and I take a look over and I go, those are 12 people I know nothing about, because they were 12 people who kept their mouth shut, because everybody who opened their mouth said something that either I didn't like or the other side didn't like. And so therefore they got kicked off. And who you're left with are the 12 people who kept their mouth shut and kept their hands down and just really didn't say anything. And it's 12 strangers you know nothing about. That is the reality of it. That is the reality of having almost no time to do. And it's what's odd about it is that's not the way it works in civil court. In civil court, they give them almost unlimited time. Because I guess when we're dealing with money, that's more important than when you're dealing with people's lives. But it is incredibly frustrating how often you have no time to ask or talk to people about stuff. And the judges ride you on this. And I think it's the weird thing with judges, because they feel like attorneys always like to talk too much. And I don't disagree with that, but this is the one time you should let them talk too much, because it's so important to get this right. Why? Because when you don't, you end up with Jeffrey Ferguson hung 11-1. And if there's anyone to blame for that 11-1 hang, it has nothing to do with the evidence. It has nothing to do with the attorneys. It has to do with jury selection. That attorney, I'm telling you, the second that came back 11-1, that prosecutor said to himself, I wasted my time. Everything since that jury was sworn was a waste of time, because I had one juror I never should have allowed on this jury. And now I don't know what amount of time that judge gave them in that case. But if it's typical for the cases I'm used to, they didn't give them enough time. And they might have discovered that one person. Maybe not, but maybe would have had an opportunity to discover that person probably should not be sitting on that case. So that is my little tirade and rant for the day, but it was it is a great last question. It was incredibly frustrating for a judge, okay, counsel, let's wrap it up. And you're like, I want to find out who these people are so we're not all wasting our time. So because of all of that, the whole idea of trying to figure out who these people are is out the window. So what do you do in that limited amount of time? I think you're trying to do three things. You're trying to make them like you. You're hoping that you do make some good first impression with these jurors so that they find you to be likable and reliable and trustworthy. You're trying to indoctrinate them, though I'm using that as a very loaded term. You're not supposed to indoctrinate them, but you're trying to set up some themes. The theme of, circumstantial evidence, the theme of, sometimes people's actions speak louder than words, things like that. Get them used to the concepts that you hope to present in the trial itself. And then the last thing you're trying to do is just identify the crazies. Who are the absolute people you do not want on this jury? Who are the people who are just hate every police officer and anything that's ever come out of their mouths? Or who's a person who, if you're the defense attorney, who's a person who hates the type of person your client is? Your client's a banker and they hate all bankers. You want to find the crazies, and hopefully you do, and get rid of them. And like you said, at the end of it, you're looking at 12 people you know nothing about, if you're lucky. But Alicia K's mayo was, do I have a routine, a lucky tie, lucky socks? No, I don't. But there is one thing I started doing early on that I always like to do. And that is I immediately tried to own the space. And the way I would do that is when I would walk up to speak to the jurors, I would move the podium. I would just grab a hold of it, and whether or not I moved it 2 feet to the left or right, I moved it out of my way. And I wanted to subconsciously, and this is pure trial strategy stuff I'm giving you guys here. I would want to send the message in some sort of subconscious way to those jurors that I now own this space, that I want to change the energy in the room, that, if you're a prosecutor, it worked even better because the prosecution goes second in voir dire. So they now have had the defense attorney get up and maybe given some really boring and awful voir dire. And I've seen some bad ones, where they'll go through each potential juror. Juror number 1, do you promise to view my client as innocent until proven guilty? Juror number 2, do you promise to, and and the people, their eyes are glazing over and they're thinking to themselves, why in the world couldn't I find an excuse to get off of jury duty? And then when I would get up, I would try to just change the energy. Hey, everybody, how are we doing? We hanging in there? Do we need coffee? Do we need a break? Everybody feeling good? Move the podium out of the way, walk up to them, create a little energy, create a little space, and just subconsciously, hopefully make a good impression so that what they feel like the rest of what's going to come out of my mouth isn't going to be straight BS, but is something they can rely on, something they hopefully find me a little bit likable on, something that wakes them up. And if you can make them like you, get them indoctrinated with some themes and identify the crazies, I think you're doing about the best you can do. That is all of our questions. You guys have been fantastic. Thank you so much. Let's do some quick announcements and then get us all out of here on to our Sunday. If you missed it, oh, Ashley, thank you so much. I'm so happy you decided to start Courtroom Confidential. It's rare we get to have a relationship with someone we watch on TV. You're awesome. Thumbs up. Thank you so much. Very sweet of you. What you missed. Yesterday, we had our new weekly roundup because we're doing that on a new day, and it's a premiere. It was live. Tiffany was in the chat. We talked about Kohberger, Menendez, Huerman, a bunch of other stuff. If you guys haven't watched it, please watch it after this. We put a lot of work into those weekly roundups, and we hope that you enjoy them. Monday, tomorrow, we don't know what we're going to do, right, Tiff? Are we still up in the air about what we're doing tomorrow? We're trying to figure it out. We will keep you posted. We may do a live, we may do an interview, or I may be on somebody else's show, but we do not have a conversation set up. We're setting up our next conversation, but we're taking a break from that on Monday. But on Wednesday, we do have something set up for you, and that is that we have Lauren Matthias from Hidden True Crime is going to come on our Wednesday night live to talk about the Corey Richins case coming up. She's been following that. She's been doing some deep dives. I'd love to hear her thoughts. So we're going to hear from her for a bit. That will be at 5 p.m. Pacific, 8 p.m. Eastern. Check out Wednesday Night Live. Bring your questions for Lauren. She's, in the weeds on this case, and I can't wait to hear us. And as always, if you guys enjoyed today, if you liked, hold on. If you liked hearing these questions and you want to participate yourself, how do you do that? You're asking yourself. I'm going to show you right now. You go to thecourtroomconfidential.com and you press on the send a voice message and you leave us a voice message, and do it right now. Do it right now. I don't care if it's a couple of weeks old by the time we get to them again. We love doing this. This has become one of my favorite shows that we do, and I would love to do it more often. And if we start to get more questions, we will start to do it more often. But we need to get those questions and comments from you guys, and you can see how fun they are and how they really make the show. So, thecourtroomconfidential.com. click on leave us a message. Leave us a message. Do it now if you haven't already. We'll listen to them again in a couple weeks. If you want to join our membership, you can also do that from the website. Become a member. If you want to shop for merch, you can also do that from the website. Click on the shop. And if you have merch, send us a picture, and we would love to put it up if you guys are okay with that. In the meantime, that is it. You're all fantastic. I'm so glad that you all decided to stick around. This has been a blast every single time we do these Sunday Fun Days. I feel like it's a blast here too. Let me make sure I just thanked everybody. Rosie's Overruled. Thank you for being a member for a month. Happy to be here. Who else do we got? Jammin became a YouTube member. Thank you so much, Jammin. Appreciate that. Captain Rhett Snuggler became a member. Rhett Snuggler, I love it. Thank you to the captain. Andrew C became a member. Thank you guys again for all your support. Couldn't do this without you. Kale became a YouTube member. You're all fantastic. Thank you for spending some of your Sunday with us. Canone's Baloney. That's fantastic. Canone's Baloney. Thank you so much for that. Dr. Bull Butter, I love this channel. Josh and our sweet T Suze, I love her too. Oh, Mama She, you're fantastic. Thank you again for all your support. Is that everybody? Did I miss anybody? That's everybody. You're all fantastic. Have a great rest of your Sunday. Have a great rest of your weekend. And thank you again, guys. We'll see you again soon. Take care.